The views expressed here are for educational purposes and reflect personal interpretation, not legal advice.
Right, 6. Despite Article 164, the remuneration and benefits payable to a judge who is suspended from office under Clause 5 shall be adjusted to 1/2 until such a time as the judge is removed from or reinstated in office. So, mshahara yake analipwa nusu.
Baka atolewe ama arudishwe.
Hivyo ndivyo kunaenda. Alright? Number 7.
Number 7 says, a tribunal appointed under Clause 5 shall A. be responsible for the regulation of its proceedings subject to any legislation contemplated in Clause 10 and B. Inquire into the matter expeditiously and report on the facts within
and make
binding recommendations to the president.
Right. So wao ndio they are responsible, wao jishughulikie. Make sure that you give very good findings and then make sure you present the recommendations to the president. Now, a judge who is aggrieved by a decision of the tribunal under this article may appeal against the decision to the Supreme Court within 10 days after the tribunal makes its recommendation.
Nice. The president shall act in accordance with the recommendations made by the tribunal on the latter of A. The expiry of the time allowed for an appeal under Clause 8 if no such appeal is taken, or B. the completion of all rights of appeal in any proceedings allowed for under Clause 8. If an appeal is taken and
if such an appeal
is taken and the final order in the matter affirms the tribunal's recommendations.
So what is the president supposed to do? Say the judge has been is being investigated, right? So they've been suspended from office. Their salaries are half. There's a tribunal. They're investigating. They present recommendations to the president. Now, what the president does is within 10 days, okay, the expiry on the letter of the expiry. So after the 10 days have expired for the appeal, then what does the president do?
He's supposed to take to
and they affirm the tribunal's recommendations.
The final order.
Yes. And finally, Parliament enacts the legislation providing for the procedure of a tribunal appointed under this article. Ladies and gentlemen, now that is the final bit of the previous video. And we are back. Now we are supposed to be handling subordinate courts. Welcome to We the People podcast. Yes, kama kawaida, we read the constitution, we go through it, we just understand it. So that we can understand how is this country supposed to be run currently. And then now we know what type of changes are supposed to be pushed in order to make sure that this country is run perfectly.
Yes.
Sasa, we are Kenyans and Kenya is our business. This is Mastermind. Part 3 of Chapter 9.
Subordinate courts.
We discuss the subordinate courts. We are in the judiciary. Okay? Yes. So the subordinate courts, Article 169. The subordinate courts are A.
The Magistrates Courts.
2.
The Kadhis Courts.
C.
The Courts Martial.
And any other court or local tribunal as may be established by an act of parliament other than the courts established under as Article 162(2) requires. Okay, other than the courts. So which courts are those? The ones in Article 162(2) are,
the superior courts.
Yes. So let us go. Part 2 of that says,
the Parliament shall enact legislation conferring jurisdiction, functions and powers on the courts established under Clause 1.
The courts above. Alright. So the Kadhis Courts. What are the Kadhis Courts? The Kadhis Courts, Article 170, Part 1. There shall be a chief Kadhi and such number being not fewer than 3 of other Kadhis as may be prescribed under an act of Parliament. All right. Number 2.
A person shall not be qualified to be appointed to hold or act in the office of Kadhi unless the person A professes the Muslim religion,
lazima kuwe Muslim,
and B possesses such knowledge of the Muslim law applicable to any sect of Muslims as qualifies the person, in the opinion of the Judicial Service Commission, to hold a Kadhis Court.
So you must be qualified. All right. That's the point. Parliament shall establish Kadhis Courts, each of which shall have the jurisdiction and powers conferred on it by legislation, subject to clause 5. You're getting there. Okay. Number 4. Clause 4.
The clause 4 says the chief Kadhi and the other Kadhis, or the chief Kadhi and such of the other Kadhis, not being fewer than 3 in number, as may be prescribed under an article of Parliament, an act of Parliament, shall each be empowered to hold a Kadhis Court having jurisdiction within Kenya.
Okay. All right. So the chief Kadhi and other Kadhis, or whatever other number, not fewer than 3. All right. They may be prescribed. So the act of Parliament is the one that determines. All right. These stories of Kadhis Court. So we shall get to that act of Parliament. Discusses. So what is this clause 5 that we are talking about? The jurisdiction of a Kadhis Court shall be limited to the determination of questions of Muslim law relating to personal status, marriage, divorce, or inheritance in proceedings in which all the parties profess the Muslim religion and submit to the jurisdiction of the Kadhis Court. So not all cases, okay? A murder case will not be handled in the Kadhis Court. All right. The case that can be handled is marriage, divorce, inheritance, or personal status. All right. All right. Let's go. And you must be a Muslim for you to be taken to the Kadhis Court.
Both parties actually.
Yes. All right.
Yes.
So that is basically the Kadhis Court, the one subordinate court that is discussed in this specific part. So
that is how part 3
goes.
Yes.
All right. Ladies and gentlemen, we are going to go straight to the Judicial Service Commission, part 4.
Which is part 4.
This is quite important because it is the board that is supposed to govern the judiciary. Now, we need to understand, Parliament has the Parliamentary Service Commission. The public service, the executive has the Public Service Commission. And we have the judiciary having the Judicial Service Commission. So let us get to them.
So there is the establishment of the Judicial Service Commission.
That is sub-article 1.
Yes.
Sub-article 2. Let's go. The commission shall consist of A, the Chief Justice, who shall be the chairperson of the commission. B, one Supreme Court judge, elected by the judges of the Supreme Court, who will say that 7 in number. C, one Court of Appeal judge, elected by the judges of the Court of Appeal, who will say that how many number? At least 15. All right?
Yes.
One High Court judge and one magistrate. And one a woman, one a man, elected by the members of the Association of Judges and
Magistrates.
So how many members do we have?
We have the
CJ
as the chair and as the chairperson.
One judge of the Supreme Court, one of the Court of Appeal, one of the High Court, one magistrate, a man and a woman. So we have 7
already.
All right. Then we have the Attorney General. Then we have 2 advocates.
We have a woman and a man.
Each of whom
at least 15 years of experience.
Elected by
members of the statutory board responsible for the professional regulation of advocates. That is the case.
2 advocates. All right. We are not at 9. No, we are actually at 10. All right. 11. One person nominated by the Public Service Commission. Right. And
1 woman and 1 man to represent the public, not being lawyers, appointed by the president with the approval of the National Assembly.
So we have about 13 members of the
the
Judicial Service Commission. Sorry. All right. Let's go.
So
another one. Number 3.
That article says, that sub-article says, the Chief Registrar of the Judiciary shall be the secretary to the commission.
Okay, so that is another member who is not, their job is given.
Yeah.
The secretary, who is the chief registrar. So that is the 14th member.
And then the other members of the commission, apart from the Chief Justice and the Attorney General, shall hold office provided that they remain qualified for a term of 5 years and shall be eligible to be nominated for one further term of 5 years.
All right.
Yeah.
Thank you very much. Functions of the Judicial Service
Commission.
Article 172. 1.
The Judicial Service Commission shall promote and facilitate the independence and accountability of the judiciary and the efficiency, effective and transparent administration of justice, and shall A.
Recommend to the President persons for appointment as judges.
B. Review and make recommendations on the conditions of service of
1.
judges and judicial officers and other
than their remuneration. So they don't handle money.
Other than their remunerations.
And
the staff of the judiciary.
All right. What else shall they do? They shall appoint, receive complaints against, investigate and remove from office, or otherwise discipline registrars, magistrates, and other judicial officers and other staff of the judiciary in the manner prescribed by an act of Parliament. All right. D. They shall also
prepare and implement programs for the continuing education and training of judges and judicial officers. And E. They shall advise the national government on improving the efficiency of the administration of justice.
So that is Article 172, Part 1. All right. What we are saying that they shall promote and facilitate the independence and accountability of the judiciary and the effective, efficient and transparent administration of justice. And they shall also do what? Recommend, they shall review, you get. So they shall appoint, they receive complaints, you get, they investigate. Their job is to basically, they are the watchdogs of the judiciary. So if you have an issue with a judge,
JSC is the place
to go.
Yeah.
Right. In the performance of its function, the commission shall be guided by the following. A. Competitiveness and transparent processes of appointment of judicial officers and other staff of the judiciary. And
B. They shall have the promotion of gender equality. Gender equality.
Gender equality will guide. So make sure we don't have more than 2/3 of judges in Kenya being one gender. All right. That is the rule. All right. So Judiciary Fund. Article 173 talks about the money.
Who handles the money in the judiciary.
Yes.
Now,
173(1).
It says there is established a fund to be known as the Judiciary Fund, which shall be administered by the Chief Registrar of the Judiciary.
The fund shall be used for administrative expenses of the judiciary and such other purposes as may be necessary for the discharge of the functions of the judiciary. All right. Number 3.
Each financial year, the Chief Registrar shall prepare estimates of the expenditure for the following year and submit them to the National Assembly for approval.
Each financial year. So what happens is, money needs to be given to the judiciary for its functions. All right. So this money will be allocated by the Parliament. But who asks for the money?
The Chief Registrar.
All right. Yes. On approval of the estimates by the National Assembly, the expenditure of the judiciary shall be a charge on the consolidated fund, and the funds shall be paid directly into the Judiciary Fund. All right. Number 5 says the Parliament shall enact legislation to provide for the regulation of the fund. Now, Kenyans, recently we've had the Finance Bill 2026-2027 being tabled in Parliament. Have you seen it? Have you read it?
Did you go through it?
Did you go through it? It is the highest budget ever to be recorded in this country. 4.9 trillion. 4.9 trillion, actually almost 5. This money, there is some money that has been allocated to the judiciary. There is some money that has been allocated to the executive, and there is some money that has been allocated to the legislature, the Parliament. Now, the question is, which arm of government requires more money in order for it to run its activities? 2. If this arm of government requires more money to run its activities, then what are its activities? And then number 3, once it is given this money, is it doing what it's supposed to do? We've already seen where the money for the judiciary is supposed to go. Okay? We've already discussed the cabinet. We have already discussed the legislature, the 3 arms of government. Ladies and gentlemen, this country is under siege. One arm of government wants to take over the others. We need to go into the constitution and figure out a way in which we can make this work. The system needs to work. Not for a specific few Kenyans, not for the rich, not for the politicians, but everyone. Yes. This is We, the People Podcast.
Information
is power.